Good day, ladies and gentlemen. Welcome back to Crimlaw TV. This week we're going to discuss Virginia case law for August of 2010. So let's get to it.
The number you have reached, 911, has been changed to a non-published number.
Welcome back to Crimlaw TV, and like I said before, we're going to discuss the changes in case law or the cases that were decided August 2010 that are pertinent to Virginia, mostly from Virginia's own courts. So we'll start out with constitutional issues. Fourth Amendment, there were a few cases this in August. The first we're going to talk about is Joyce against Commonwealth. And in Joyce, the court decides that, if there's probable cause, it doesn't matter whether the officer has placed someone under arrest before or after he does a search on someone, because there's probable cause. The facts behind this case are this: there was a guy standing behind a stop and rob somewhere. He's behind or on the side or something. Doesn't go in the store. Doesn't do anything. The officer believes he's doing drug deals. Walks up, does a consensual encounter, starts talking to him, and then decides to do a search. Searches him, finds contraband, and thereafter arrests him. The court basically says, well, he was trespassing anyway, he knew he was trespassing, and therefore probable cause existed for an arrest, and the officer could do it, and therefore there's no problem with the search. Number two, exigent circumstances. This is Smith against Commonwealth, and in Smith against Commonwealth there was an anonymous call saying there's this guy and that guy in an apartment doing a drug deal. It describes the two guys, but it's an anonymous phone call. Officer comes up, knocks on the door. One of the guys opens the door a crack. The second guy in gets up and starts running out of the room, and the officer sees something white in his hand. The officer then forces his way in, stops the second person, who, and obviously doesn't find anything on him. But on his way back out, he sees pipes, everywhere, little glass pipes. Has it searched and has them analyzed, and contraband's found on them. So this is, the question then is, was there exigent circumstances? Was there probable cause? Well, the exigent circumstances is fulfilled by the fact that the man got up and was running, had something in his hand, looked like he basically, go flush it down a toilet. Probable cause is trickier here. Obviously, as we all know, an anonymous call doesn't cut it unless there's something that corroborates it. And in this case, they say that since the two individuals who were on the premises looked like the description in the anonymous phone call, that's enough. And then when one of them gets up to run to another room, that establishes the exigent circumstances, and the probable cause is already there. Exclusion. Fitchett against Commonwealth. Exclusion is only to be used when the evidence is gotten directly from an unconstitutional search, seizure, or during or as a direct result of the unconstitutional search and seizure. Something that would not have come to light but for the unconstitutional search and seizure is not necessarily excluded. If there is a subsequently discovered item that is somehow separated from the original unconstitutional search, then it is it can't be excluded. The facts in this case are this: the officer is going to do what is plainly an unconstitutional search on the defendant, the suspect. As he starts the search, the suspect runs. As the suspect's running away, he falls, and from his waistband falls a firearm. Suspect gets up and runs again, and he's caught. And he is a felon in possession of that firearm. would have never been found but for the officer starting the original unconstitutional search. But the Court of Appeals of Virginia says that these two things are separated from one another. Um, Adkins against Commonwealth. Okay, this is about being a passenger in a car. And basically the rule that comes out of Adkins is this. If you are a passenger in a vehicle and you do not assert some sort of possessory interest in the vehicle or possessory interest in the item that is found, the contraband that is found, then you don't have any right to assert a Fourth Amendment defense. They come up with 5 factors. They say it's a totality of the circumstances test, but they come up with 5 factors. You show a possessory interest, show you had a right to exclude others from the vehicle, show that you'd exhibited a subjective expectation of privacy in the vehicle, showing an exorcism of control over the vehicle, or showing you took precautions to maintain privacy. So basically, unless they say that the car is theirs or the item which is found is theirs, they can't assert that Fourth Amendment right. Then they go on to say that a passenger does have a right to assert a defense against the stop, the seizure, because he's seized as well with the driver. However, then they go on to say that as long as the stop is reasonable in length, the officers can detain him without any kind of cause whatsoever, as long as the stop's ongoing. And in this case, the facts are the officers pull over the car for defective equipment, the lights out on the license plate, and they find out that the driver has warrants outstanding in both New York City and Los Angeles, California, which is pretty impressive. You don't usually see that combination. And while they are holding the driver and talking to her, trying to ascertain whether the warrants are still good or whether they can be, whether the other states want to extradite her, basically, and they bring in a dog to search the car, or well, it's not a search for the dog to sniff the car. During this time, they have already taken the defendant's ID, checked his ID, and returned it to him. At which time he attempts to leave and is stopped by the officers. Contraband's found, of course, etc., etc. But he's stopped by the officers and asserts that once the ID is given back, he has a right to leave. And the court basically says no, they have a right to detain him until the end of the traffic stop, as long as it's a reasonable length of time. This, I think, may be the weakest decision of August. In general, not in general, in almost every case, when the ID is returned, the court will say, and at that time, John Smith can leave the scene. And at the moment the ID is returned, it becomes a consensual encounter. This is pretty much the lay of the land. When the ID is returned, it switches from a detention to a consensual encounter because the ID is what's keeping him there. They've already checked to see that he's okay. So this is a difficulty with this case, which I think is counter what you usually find. And you wonder, you think that if it had been important that he was able to leave after his ID was given back to him, you wonder if the court might not have found that, well, once his ID was given to him, he could leave, and therefore. So I think this is the poorest case of August. Well, we may see. I get more cases come. Okay, Sixth Amendment, the right to counsel. And this one is about, and this comes from the Fourth Circuit, U.S. against Cooper. And it's about the right to be told by your defense counsel of your right to appeal a case. And they basically say, well, generally it is, ineffective assistance of counsel if you don't tell your client that he has a right to appeal his case, but it's not a per se rule. And then they lay out, a 2-part test. One is, would a rational defendant want to appeal this? and they go through this big thing showing how the defense attorney had gotten his client the minimum sentence he could get, had done a wonderful job for him, and wasn't going to get any better, basically, or at least that's the way you can infer from what they're talking about. And the second is, did the defendant demonstrate to counsel that he was interested in appealing? Did he say to the counsel on record in court, "I want to appeal this," or wherever? The claim here by the defendant was, and this was raised about a year after he'd been convicted in a habeas hearing, was that I told him I wanted to meet with him the next day in jail because I didn't have any time to talk to him after I was found guilty because they got me out of that courtroom right away. We've all seen this happen. Now, generally, marshals, um, deputies, etc., will let you have a word or two with your client, but sometimes, that bus is waiting outside and they're moving him as soon as it's done, right? Or somebody they're really worried about security-wise. They're just moving him as soon as it's done. And he says he wanted to talk to his attorney, and the attorney never came to the prison or the jail the next day to talk to him. So he was never able to tell his attorney he wanted to appeal. Apparently didn't write a letter to him or anything. Um, and basically, the court says, unless the attorney knows the defendant wants to file that appeal, or it's really obvious that any rational person would want to file that appeal, well then, there's no grounds for habeas. I think this is a really poor decision because what it does is it encourages defense attorneys from the moment that the case is over, in which the defense attorney will almost always say, "Hey, that's the best deal I was going to get for him," which is almost always true. The moment the case is over, that defense attorney wants to get away from that client as much as possible, so he has that he's not being told to engage in a spurious appeal, which a lot of clients want. And so this is a poor policy behind this. Make the defense attorney run away from his client.